Hi, welcome back. I'm Rodney Peyton, and today on Beyond the Gavel, I'm joined by Dr. Herschel Lessin. He's a distinguished pediatrician with over 40 years of clinical practice and 30 years as a medical expert witness. He trained at Stanford and Yale, and he's combined frontline care with national policy leadership through the American Academy of Pediatrics. Beyond the courtroom, he's been a driving force in practice management, physician networks, and quality improvement, shaping how pediatric care has been delivered to tens of thousands of children across New York's Hudson Valley. In this episode, we're going to explore his unique perspective on the crossroads of clinical practice, medical legal testimony, and the business of medicine. So, Herschel, welcome so much to Beyond the Gavel.
Well, thank you for that introduction. My cheeks are getting red, I think, but I appreciate it.
So, Herschel, tell me how you got into this in the first place. How did you start in medicine? Was that something you always wanted to do, or why did you do it?
No, I always wanted to do medicine. I was one of those kids that would run down the hall and have to be tackled by staff to get a shot. And I think I went into medicine because I wanted to be on the right side of the needle. And so I've always wanted to do medicine since I'm a little kid, and that's what I did.
Yeah, so you had that drive. I did that too. I had my tonsils out when I was about 4. And in those days, as you remember, parents weren't allowed to turn up very often. And my mother came in to see me, and I told her to go away because I was about to do my ward round. And ever since then, I want to do surgery. And that was focused. That was
Great.
focused. So how did you get into the legal side of things?
Well, it's interesting. I was just 3 years out of practice when I was named in my first lawsuit that I was named in. And being young, maybe a little stupid and a little headstrong, I knew the case was nonsense, but I knew nothing about the process. So I eventually got dropped after discovery, but that's another story. But at the time, I really, really went nuts and I got very upset. And I just, being the control freak I am, I decided, well, I got to get some control over this. So I decided I was going to learn about it. I read some books and I decided I was going to be an expert witness. And since an expert is someone from out of town with a briefcase, I called up the liability company and said, hey, you need an expert? They looked at my CV and said, sure. And I was only 3 years out of residency at that point. And then it went on from there.
It went on from there. And that's a very important thing you bring out. When I'm talking to lawyers, and I mean, a lot of lawyers are listening to this at various levels, sometimes they don't twig at just how much emotional impact this has on medical staff when they're on the receiving end.
Oh,
For instance,
go ahead.
the
Sorry.
figure here is 250,000 complaints for the National Health Service resolution over in the UK, and yet about 13 to 14,000 negligence cases. So all those others where doctors have been lined up and something said about them, and it's nothing, yet it has that emotional impact. Isn't that right?
It's enormous emotional impact, and what I hate about it is that you're guilty till proven innocent in your own mind, first of all, because they say all these terrible things, much of them untrue and much of them far too nuanced for lay people to really understand. And it colors you, it changes your interaction with patients. It tends to be viewed as an adversarial relationship as opposed to a supportive relationship that it's supposed to be. You're always wondering, well, how can I prevent me from going through this again? And it's terrible. It's just terrible. And you feel it for decades.
Yeah, and it never goes away, and that
No,
resilience. And yet in medical school, it's not something that's brought up, is it?
not very often, and it should be, but business is never brought up. Policy is never brought up. Private practice, at least in this country, is rarely, if ever, brought up. It's all an academic perspective, which is not what doctors need unless they want to be academic folk.
Isn't that the absolute fact? I mean, I'm professor of law, as you know, in Australia as well. And one of the reasons I'm there is to bring reality to lawyers about what the practice is, more than just reading books, the academia of law and the practice of law. And you're actually bringing up very clearly in medicine, there's the academia of medicine, which a lot of people get into because they're nerdy and they like that. And then there's the business of medicine. There's actually running a practice, your staff, whether you're in private practice or whether you're even in health service or socialized medicine, you still have staff to run. You still have to, make the practice work. So what lessons did you learn from doing that?
In running a practice, you mean?
Yeah.
Well, first thing you realize is that the most important person in the whole office is the person who's sitting at the front desk, because they're the ones who make appointments. They're the ones who take phone calls. They're the ones that can record things in the proper place, duplicate them, lose them, not follow through. And you're at the receiving end, not knowing anything about this. So in running a real practice, you have to know how the practice works, what the workflow is, who's responsible for what, and you have to pay attention to it. And doctors know nothing, less than nothing. I did a lecture on business in practice, and I have a cartoon that has a goateed guy talking to Dilbert, actually saying, he wanted some business information. And the punchline was, you mean we need revenue to make profit? And that's the state of most doctors, at least primary care doctors. I can't say for specialists, they're a little more savvy, but that's the state. And with that, primary care is dying because people can't keep their doors open in this country because payments are so low and policymakers don't care. And we have no really good voice.
It's not interesting because that actually carries across into legal practice in the States, but also in the UK and in other countries, because they're not taught that. And those same lessons that it's not you sitting in your desk with your green light on and reading, case law. It is the person who is your brand, the person who is your front door that really makes or breaks your practice. Isn't that right?
I agree. And very few people realize you're paying minimum wage in this country, at least, to someone who really is astoundingly important to your practice. And if I had my druthers, which is very difficult, I'd pay front desk people handsomely.
Mm.
But it's hard to do.
But that is so important. Your brand. We've got the two types. You brand by association. I came from Yale and Stanford, therefore I must be good because I come out of that.
Right.
I'm branded by association. But then you're branded by results. And you can come out with that and put your block up on the wall and it says this, and then somebody phones up and gets somebody nasty or somebody that doesn't care at the other end. It doesn't matter where you came from, you're destroyed. And that happens in law as well as in medicine. So there's an important message that you're giving out there is watch your staff, choose them wisely. They reflect on you. They're the front door of your practice. And they're branded by you. And if they screw up, you get branded
You
by
get
them.
branded. And if you don't pay attention to them, you're really going to get hurt both economically, reputationally, and just crazy level of craziness in the office because things don't work right. And it's just so important to get the practice running right, because I tell physicians when I do business lectures is no margin, no mission. You can be all for the care of children and be very compassionate, but if you have to close your doors because you can't meet payroll, at least in the US, what kind of care are you providing to children if you're not opening your doors anymore?
That's right. And the lawyers are the same. I mean, they come on here, they have the thing no in, no fee, and that happens across the board as well. But some of the young ones coming in are so full of I'm here for the good of everybody. And you have to put a hand on their shoulder and say, just a minute, this is a business.
Exactly.
And the business has got to make a profit. And one of the messages that we got to get across to lawyers is you don't take on cases that aren't going to run. And you need to screen a case out right at the beginning, because several things. You can spend tens of hours and thousands on a case which is going nowhere. And that might be financial to you, but it also is emotional, as you've just brought up, to the medical staff at the other side. 60 to 70% of midwives have been involved in anything about birth trauma and taken to court peripherally, never work again. That is awful.
Devastating. It's devastating. And it's just such a shame that there can't be a process where when something goes wrong, you say, okay, I goofed it up. I'm human. Let's make a reasonable compensation. And they're trying to do that in this country. It hasn't really taken flight, But when it's an adversarial process like it is in court, doctors are not used to that. When I talk to doctors, I say, what's to a reasonable degree of medical certainty? And they raise their hands and say, oh, 95% certainty is reasonable certainty. I say, no, it's not. It's 50% plus a feather. It's more likely than not. And they do not get that.
No, and it's very difficult for them. And yet, if we failed everybody that got less than 50% in an exam, you'd have 50% less through. And then every year, if you say, well, we'll drop the bottom 50%, you'd very soon be left with me. That's it. You know what I mean? That would be a problem here. And there is that. A standard is the lowest form of acceptable performance.
Exactly.
That's what a standard is, the lowest form of acceptable performance. So when I'm asked the standard of care by a lawyer, what's the standard of care in this A&E department things? It's the lowest form of acceptable performance. And guidelines don't always cover it.
Not at all. And guidelines are guidelines. The Academy of Pediatrics publishes a guideline and they have the huge disclaimer, this is not meant to be a standard of care. Clinical situations may vary and it should not be used as such. But that's not the way it's portrayed in court. And it's hard for you as a doctor to explain that your association's guidelines don't need to be followed.
Well, they don't, and because it's all circumstantial. It's all circumstantial. What's the context? So that takes me through to you working as an expert witness. Now, you've worked on both claimant and defendant side.
Absolutely.
I mean, you've done both. So how do you explain that to a lawyer, and how do you set about explaining that in court without being glib about it, that, this is what I see. For instance, a child with cerebral palsy is a tragedy. And they have to prove wrong. One child gets cerebral palsy and gets a hell of a payout. Another child gets cerebral palsy, but because you can't prove it wrong, get nothing.
True.
And that's an inequality in itself, isn't it?
Absolutely. And how do you go? But when I take my first call from a lawyer, I say, listen, I'm going to give you my opinion, whether you like it or not. Okay. And if you can't live with that, then don't hire me, because I'm just going to give you my opinion. And that's what you're paying me for. And you're paying for my opinion. And I am not going to alter my opinion for your case theory.
Absolutely. And I mean, the point is that, by definition, a lawyer's an advocate for their client, whether that's defense or whether that's plaintiff. They're an advocate for their client. They are biased by definition.
Yes.
As a medical expert, we need to stay in the middle of the road, down that line in the middle of the road. If there are two experts, there shouldn't be a blade of grass between them. If there is, somebody is flying off to bias. There may be nuances that you can discuss, but you and I talking about a case should not be at loggerheads of each other. We can agree there are these wobbles and they may come down on one side or the other, but there really shouldn't be that big a difference between us, should there?
But in this country, it's enormous. It's just enormous. And court is not necessarily about actual facts or liability or competence or failure of the standard of care, at least with children, and maybe more so than adults. It's theater. And whichever lawyer can present the best story is going to win. And often the case facts be damned. It doesn't matter. So I try to explain it that I'm an advocate as an expert. I'm an advocate for the truth. I'm an advocate for my opinion, and that's it. And I am not going to be an advocate for the patient or for the defendant. I'm advocating for myself and the truth. And in this case, my opinion is there was negligence or there was no negligence. And here are my reasons.
Exactly. And that's important. So it's important lawyers understand that good expert witnesses may not be good as far as they're concerned for their case that they think they have. Get the emotion out of it. No harm. But if you are looking, and I know, we see a child that's badly hurt, hear it. But somewhere you've got to get the emotion out. The facts and what is likely to be the right truth of it.
Right, but
and the emotion can't be allowed to pull you.
But the emotion is what sways the verdict, at least in this
Exactly.
country. And
So justice.
what's justice? It's like obscenity. I know it when I see it, you know. It's very hard. I mean, justice ought to be a settlement if someone's injured due to the negligence of others. And I wish we had the Europe. I don't know if the European system is that the loser pays the winner pays the loser pays the winner's fees or something like that. So plaintiff's attorney had to pay the several $100,000 it cost to do a defense case. That would cut down on civil suits quite a bit. And in this country, it's, you lose either way. I mean, the defense lawyers get paid by the carrier in this country, so they don't lose unless they tick off their insurer by losing too much. And the plaintiffs have little reason to settle when they can wear people down with discovery requests and back and forth opinions and such, which are very expensive for them too. But if you're going to spend six figures in a case or more, you darn well better have a good case.
And there's some people who start a case and then they spend money on it, without doing that preliminary screening, and then they need to get their money back. So they'll push a case which shouldn't be pushed.
And hope for
And the
settlement.
longer it goes on, the more emotion is added to the family, if you like, that is concerned here. They think they're going to win. They get more and more angry. They get more and more upset. And if you have to turn around at the end of the day, say there isn't a case, say, what? It's taken you 3 years to tell me that. And
Yeah,
the other side of it is the medical staff who are on the receiving end of this. So for neither side is there a benefit for not getting in there early, for not screening a case properly right up front,
exactly so.
deciding whether there's likely to be a case and not likely to be a case, and putting it to bed at the earliest possible opportunity. And if there is a claim, then settle the damn thing and stop fighting it.
Yeah, and the if the lawyer would just say, "Hey, I'm going to lose this one. I don't have a case," and that's my opinion is that there is no case. I offer to write a letter to the parents for my attorneys who retain me, saying this is why you don't have a case, because the lawyers they feel a little funny doing that. They don't feel right
Let's
telling them
face it, they
there's no
can't
case.
explain it. You tell them it's because of this, this, and this. They don't understand.
Right,
What is the old thing? They don't know what they don't know, but they think
exactly.
they do. And therefore for them to explain, and I think that's a very powerful thing. If you can get the expert to put something in writing in simple terms that their client can understand. And
Exactly.
that's a very good message about expert witnesses is when you have a relationship with them, there should be a relationship that you would say to them, right, I get it. Can you explain it to me clearly and give me something in writing that I can give to the client to explain why?
Yeah, I offer to do that, and most attorneys are surprised when I do, because I don't
Yeah,
think too many experts do that, and they should.
they should.
If you're helping the attorney keep everyone calm and rational and explaining why there's no case. Now, if there's a good case, I've seen, it makes it sound like I'm talking about frivolous plaintiffs all the time, but I'm not. I've seen frivolous defenses that are just so ridiculous, I can't believe it. I've heard experts say things that are anatomically impossible in open court and under oath,
Yeah.
and it's anatomically impossible, but
And
no
it's
one's
stupid. I
there
mean,
to challenge
eminence is not the same as expertise.
it. Right.
Just because somebody has a reputation in a town or a village or a state doesn't mean they're good expert witnesses. Doesn't mean
Exactly.
that at all.
And I think the
And
message for lawyers should be this. There's a fallacy in Latin. I always goof it up, but propter hoc ergo, oh God, I don't know what it is. Propter hoc ergo something hoc, meaning just because it's there doesn't mean the preceding events caused it.
yeah,
Okay. And lawyers don't get that very much. They say, well, this kid was damaged at birth. It's obvious that the birth injury did it. And that's not true. And I use that message in court all the time because that's a logical fallacy. And it's like my hip cases, the congenital hip cases say, well, it wasn't diagnosed till he was 2 years old. And everyone says it should be diagnosed before 6 months. Well, my question is, was it diagnosable before 6 months? And
and
just
just
because
because they
it's
do
there,
the tests at birth and at 6 weeks doesn't necessarily mean you're going to pick it up. The
That's true.
tests are only about 60% accurate in the first place.
I know. But people don't understand that. A test is a test, you know. If it's abnormal, then something's wrong.
And it's a
So
statistic. That's the bit they don't get. It's a statistic.
what's the nuance? It's complicated stuff. That's why when I see, excuse me, I'm not pointing fingers at academics, but I love going up against academic experts who try to testify against community primary care because they don't know what they don't know. And and what I say in court sometimes is you're trying to get Dr. X, a specialist, to testify about the 1% of referred cases he sees and what the standard of care is, and ignore the 99% of the cases he doesn't see, which I see, and which this should have been one of them. And they don't know what they don't know. And some of them are very good at talking to people. That's why they're good and they can get popular. But a lot of them are just, let's just say, not socially popular. And they tick people off and it's very flat and it doesn't work. So if you're getting an expert, get someone who can communicate with the jury, who makes eye contact, who knows how to sit, who knows how to answer a question and learns the traps. Because when I started 30, 40 years ago, I read books. Very few experts read books. How to be an expert witness. What are the magic words? What should you never say? What should you never let a lawyer do to you? And they figure, well, I'm an expert. How hard could it be in court? And when they say a newbie, because they're, at Harvard, and they're a world's expert, that doesn't mean they're any good in court.
No, it does not, because they don't know the law and they don't see that you need to know negligence is very specific legal concept.
Right.
And just because things don't work out doesn't mean that that specific legal context is in there. I wouldn't do that. Doesn't mean that a reasonable majority of people would.
Right. I tell people you really ought not to testify unless you understand the basic terms. I have a lecture why the courtroom is not the same as the exam room. And all those the definitional things I said earlier are quite true. What's the standard of care? What's more to a reasonable medical certainty? What's, causation? That's another item that's a bit, obviously, a very huge issue. So it's good to get someone on both sides that understands how the rules work.
That's vital. And I think that's a great place to end on. Look, Hirsch, this has been a great conversation. I hope it's been, that the lawyers listen to what you have said from your years of experience. You're very good at this. You have lectured on it, you've done the academia, and you've done the practicality. And you've pointed out, that we need to be central in this, central but not off to one side or the other side. We need to understand our medicine, we need to understand the law, and we need to be great communicators so that not only can we explain to the lawyers in the court, but we can explain to the clients, whichever side they're on, of exactly why we think what we think and the evidence for it.
Great.
My friend, thank you so much for spending time with us today. It's been absolutely great. Thank you so much.
Pleasure being here. I'm honored you asked me.